Welcome to the second installment of Pierce Atwood's webinar series for bankers, COVID-19 Storm and Recession Aftermath. In keeping with our storm metaphor, we're calling today's installment Landfall, Forbearance and Early Stage Workout Structures. My name is Jack Manheimer, and I am pleased to present today's session with my partner, Chris Currier, who's really the force behind this webinar series. Most of you joining us today attended our first installment, Batten Down the Loan Documents. So you've heard from Chris already, and you know that he knows his stuff. I'll try to attain the same high bar that Chris and Rick Novak set last week for us in the first installment of the series. We're going to follow basically the same format we did last week. If you have questions, there's a Q&A bar icon that you can hit and post your question, and we'll try to answer them in the course of the presentation. So I started my career as a lawyer in 1983 at the New York firm of Fried Frank, Harris, Shriver, and Jacobson. I joined the bankruptcy group right out of law school, and I've been a bankruptcy and creditors' rights lawyer ever since. And I'm embarrassed to say that's nearly 40 years now. So that means this is going to be my fourth recession as a bankruptcy and creditors' rights guy. I missed the 81-82 recession, but I was around for 90-91, 2001, and 2008. And many of you attending today, I met during one of those recessions. The 2020 recession, the one that's just starting now, is certainly going to lead to a flood, to extend our metaphor, of defaults across a broad swath of industries. Already, we've seen the beginning of a wave of retail bankruptcies. We are sure to see in the coming months hotel bankruptcies, restaurants, leisure companies of all kinds, tourist-dependent businesses, and then all kinds of additional businesses. Nobody really knows what to expect. Will the average business revenues drop 10% in the next 12 months, 20, 25, 30%? We just don't know. And what's going to happen in the commercial real estate market? When this is all over, are we going to be working from home in the post-pandemic economy, reducing the demand for office space in all of our big cities? Again, we're going to have to wait and see. So here at Pierce Atwood, we're gearing up for a flood of workouts, forbearance agreements, and troubled debt restructurings. And you should too. Last week, we focused on the initial steps that you should be taking to prepare for this recession. Today, we're going to focus on what to do when you actually begin to engage with your borrowers, who, if they haven't started already, will be contacting you soon, seeking all kinds of accommodations. And so with that, I should have done this already. With that, I'm going to turn it over to my partner, Chris.
Thank you, Jack. And just a few words about myself. I started my legal career in '93, so I caught the end of that recession and sort of the aftermath of it in the 90-91. Started out in New York, working on a lot of residential and commercial foreclosures for a number of different banks in upstate New York. And then began my legal career in Boston in '96, and have worked with a lot of banks through my entire career, both on commercial lending and also on and workouts. So spent an awful lot of time in 2007 and 8, and seemed like a year and a half after that on workouts, and learned a lot of lessons during that period about what to look for and what to do, and how these things shake out. So not to walk over our same footsteps that we walked over last week, but just to highlight some of the things we talked about last week because they're relevant to first steps to take now, and that would be to create a list of loans and categories of loans by different industries that you expect to see in workout, and that'll obviously be a long list, I would expect, for one reason or another. There was a recent study that came out, I think, from Stanford, that estimated, and it's just an estimate, but it's kind of sobering, that 42% of businesses are not likely to survive and be able to come back online when the switch turns back on. That's very, as I said, very sobering, and should obviously make everyone sit up and take notice and start to create that list. In connection with that list, it's important then, as a next step, to formulate a plan as to how you're going to deal with each of those loans. And that plan can be by industry, as to how you're going to treat, for example, restaurant loans, and also should be more specific with respect to each individual loan, because each borrower and each facility will have its own unique challenges. But again, there'll be some similarities that you can plan for. Rick mentioned last week, which is a very good point, that you need to figure out pretty early on whether or not your borrower is going to be cooperative or combative or indifferent. The indifferent borrower is the one who has nothing to lose, likely maybe not a guarantor of any kind, for example, and will just hand you the keys and wish you luck. That would be not a great scenario to be in, but could happen. The type of borrower that you have will greatly affect your plan. Having a cooperative borrower is, the best thing that you could hope for, because they will end up doing a lot of your work for you. And so I should highlight that it's not only important that you determine whether or not your borrower is cooperative, et cetera, but you yourself should also be careful not to burn bridges initially. Just for that reason, that your borrowers can be your best allies in connection with the workout, doing work for you, whether it be selling assets on the open market, managing properties as they get through this process, and it goes on and on in terms of how they can be helpful. You should take this opportunity as part of your plan to collect as much financial information as possible, and make the collection of that information a condition of your willingness to negotiate with your borrower and to enter into any kind of forbearance arrangement. That will be an early indicator as to whether or not you have a cooperative borrower. Your request for financial information and the lack of it forthcoming will be a pretty strong indicator that this might be a difficult workout. Those that are cooperative should be willing to provide you with that information. That information, you're probably thinking, is in the way of the historical financial records that you've obtained in the past that are required under your loan documents on a periodic basis, updated financial statements, et cetera, on the bank's form. But I think it should go beyond that in this circumstance, and that is you should try to get what we call an affidavit of financial condition, which is designed to elicit from a borrower and guarantors, under pains and penalties of perjury, a very comprehensive list of all of their assets and all of their income from whatever source. So it's a laundry list form that contains about 10 pages and has a borrower and a guarantor specify where their sources of income are coming from, what they may have in the way of assets and savings account, bank accounts, brokerage accounts, whether they have stock dividends, safe deposit boxes, interests in real estate of whatever nature or percentage, and the list goes on and on. Insurance proceeds, actions where they may be plaintiffs, judgments, et cetera, et cetera, et cetera. It also asks them to identify any gifts that they've made in the past 5 years, and also any payments they may have made in the past year or so, which, and transfer of property for less than fair market value. This information would be very helpful in a bankruptcy setting. And as I said, it's signed under pains and penalties of perjury. And Jack and I discussed a little bit before this presentation what the effects might be in bankruptcy if a borrower or guarantor were to be less than forthright in this affidavit, whether they provide misinformation or they outright lie. And Jack, do you want to comment on what effect that might have?
Sure. So first, the fact that a borrower or guarantor misrepresents information or out and out lies about information does not in and of itself raise the priority of the underlying obligations. The bankruptcy code doesn't do that. But there are a couple of potential effects. One is that under certain circumstances, if a borrower misrepresents financial information in connection with either getting a loan or working out a loan, that loan may be accepted from discharge under certain circumstances. And it's a high bar to get over to establish non-dischargeability, but it is possible. You have to be able to show that the financial disclosure was made in writing, that it's materially false, that it respects the financial condition of the debtor or an insider, on which the creditor reasonably relied, and and here's the hard one, that the debtor made or published with intent to deceive. So if you can get over that bar, you may be able to get your claims determined to be non-dischargeable. If they're secured claims, you're going to be at the top of the heap anyway, so that's not a major advantage. Two other ways that that comes into play. It, of course, if you can establish that financial information that's been provided has been inaccurate, either intentionally or negligently, it puts into play the credibility of all the financial information that's provided in connection with the bankruptcy case. And that includes historical information and the projections on which the bankruptcy case is proceeding. Because at the beginning of any case, there's going to be a full set of projections that have to be submitted in order to be able to use cash collateral and for other purposes. So it puts that. And then finally, and perhaps most importantly from the perspective that Chris is coming from here, is that it does create a basis for the appointment of a trustee or an examiner during the Chapter 11 case. And that does have interorum effect and does provide some leverage to the lender, both in the case and leading up to the case. Because a lender can certainly remind a borrower whose numbers are slow in coming or are inaccurate that the failure to provide good financial information is a basis for having a trustee or an examiner appointed in a Chapter 11 case.
Thank you, Jack. So the next piece of the plan of action should be to obtain from your borrower a forecast with respect to their business. That is for reopening and getting back on track. What do obviously their projections will be based upon a lot of assumptions, and maybe they can model them off of several different assumptions, but it gives you a picture of what they are planning and how they expect their business to develop and get back online over the next several quarters. And I am seeing a lot of lenders looking for plans that are going out to the second quarter of 2021, just because they expect that it will take some time, as we talked about last time, for the economy to get going again. And it'll forecast for you also what you need to be thinking about in terms of the relief that you may be willing to give to these borrowers. Certainly, I think covenants for this year are blown. It's going to be very difficult for any borrowers to maintain covenants that were put in place prior to the pandemic occurring. The next step is consider whether you make demand and start collection. I think you would only do that in the scenario where there was no other ability to do it, no other ability to do anything else, that is. It's certainly not a great environment to be foreclosing or selling assets presently. And also there's a legal and practical limitations to conducting a foreclosure of commercial property presently. There's not a prohibition legally on conducting a commercial foreclosure, but there are practical and other limitations. That is, title insurance companies will not insure presently any foreclosure that's conducted during this pandemic, during the state of emergency and stay-at-home orders, because they deem that any auction would be commercially unreasonable for the very fact that everyone's been ordered to stay home. So no matter how many people you have show up at an auction, there's still an argument to be made that there'd be many more had there not been an order. And therefore, it should not be considered commercially reasonable, and you will not get that title insurance which you need. So we think it's best to wait for the dust to settle, and take this opportunity to identify problems and collect as much information as you can to determine where you're going to go next. So the next slide, Jack. So there are a number of loan default enforcement scenarios that we've listed here. These are the top 4 and will, likely encompass most of your options. And we've ranked them in terms of best to worst as they relate to cost, timing, and exposure, potential exposure to the lender. The first, which we're discussing in more detail today, is the forbearance arrangement, which is a mutually beneficial arrangement where the bank and the borrower are working together to achieve an outcome that's desirable to both, whether it be payment in full or close to full, or perhaps getting back on track and reinstating the loan so that it can perform for the balance of its term. The second would be foreclosure and collection, which we just discussed. This obviously presents more challenges, cost, and delays, and also opens up the door for a borrower to assert counterclaims, making a bank, a lender, defend itself in connection with those efforts. And those who have lived through other recessions have seen that. Desperate borrowers will do desperate things and throw anything against the wall that they can in terms of either delaying or creating leverage for themselves. The third option is receiverships, assignment for the benefit of creditors, state court liquidations, which involve the liquidation of an entire company for the benefit of all of the creditors, not just the lender, you alone. A lender generally has the exclusive claim on collateral, but deficiency claims are shared by all the creditors equally, and administrative expenses. There are lots of administrative expenses, and it's a prolonged process. So not a great place to be, but one that may occur. And the final, which is the subject of next week's bankruptcy, and where no lender wants to find itself unless for some reason it's appropriate, is in bankruptcy. And the simple reason for that is it being the worst is that it provides the borrowers with the broadest power to assert rights over the lender. And there'll be much more detailed discussion of bankruptcy in next week's presentation. So before we get to a discussion of what a forbearance agreement should look like and contain, there are documents that you should consider entering into before the forbearance agreement. And the first is a reservation of rights letter. And this is a simple, generally one-page document which is provided by the lender to the borrower, alerting the borrower that the lender is aware of the existence of defaults, that it is considering, that is, the lender is considering all of its rights in connection with those defaults, and that it reserves all of those rights. The reason a lender would send this out is to avoid a borrower later taking a position that the bank lender waived its rights. That is, if you know there's a default but don't communicate that and wait 3 or 4 months before doing anything about it, a lender might say that you waived your rights to take that action and that the borrower relied upon your lack of action to its detriment. So it's just a simple, as I said, a simple letter which preserves the lender's rights. The second form of a letter or / agreement is a pre-workout agreement. And many lenders obtain these from a borrower before entering into negotiations. It's very tempting to start to discuss and negotiate what a forbearance agreement would look like with a borrower without having a pre-workout agreement in place. And it is a bit of a dangerous thing to do because communications with your borrower might be relied upon them. There might be some misstatement. A loan officer might make a statement which is considered a promise, which he or she may not have had authority to do, et cetera. So the pre-workout agreement is about a 3 or 4 page agreement, which contains essentially the roadmap that the parties agree to before they enter into the negotiation. And what it does, again, is establishes a written record of the ground rules for the negotiation. It provides that the lender is not, by virtue of discussing anything with its borrower, an agreement to agree or to amend any of the terms of the existing loan documents. It would contain a reservation of rights, again, like the reservation of rights letter, saying that any negotiation is not considered a waiver of any existing defaults, and the lender has all of its rights in its back pocket, by virtue of loan documents or law and equity. Next slide. Next slide, Jack, please. There you go. Provides that that the borrower is not relying upon a lender's willingness to negotiate to the borrower's detriment. That is, the borrower is acknowledging that they're not putting all their eggs in one basket, as working with the lender is the end-all be-all to save it potentially. The borrower should continue to explore other opportunities during the negotiation, whether it be refinancing with other banks, raising capital, et cetera. The agreement would provide that communications between the parties during the negotiation is not binding on the lender, unless and until the agreement should specify that nothing is binding unless and until the lender signs a forbearance agreement or other agreement that is the outcome of those negotiations. So it specifies that nothing that's said is considered a promise and cannot be used by the borrower or any guarantor in litigation or bankruptcy. The borrower will confirm the validity and enforceability of the loan documents and assert and acknowledge, rather, that the defaults are material and that the lender has all of its rights. It will specify what the effect of the lender's acceptance of partial payments during the negotiation have. That is, it would state, for example, that any payments received during the negotiation is not considered a waiver of default, is not considered to be satisfaction of any obligations other than, the amount of payment made with respect to that loan. It also provides that the lender is not a joint venture partner with the borrower, and that these discussions are merely, arm's length between a lender and a borrower, and the lender is not directing the business of the borrower. It provides, again, as we said earlier, the prerequisites for negotiation. That is, that before you will even negotiate, it will require the delivery of certain updated financial information and the affidavits of financial condition we discussed earlier. Provide a provision that the borrower and guarantors agree to pay all the lender's fees and expenses in connection with the negotiation and ultimate execution and development of a forbearance agreement. And this could be important not only because you want to have that right and have the borrower acknowledge it, but some loan documents may not have as robust language about fees and expenses at the expense of the borrower as they should. So this gives you an opportunity to enhance those provisions. It would provide a release of all claims against the lender and its affiliates, contain an integration clause, which is important, meaning that no other communications that have occurred have any kind of bonding or promissory effect. And you can also, I've seen this, some of the banks and lenders do this, which is to require a payment of a fee up front before negotiations can take place. Of course, that depends upon every situation. How much time and energy is it going to take for you to have these negotiations with your borrower? Resources are expensive, but given the circumstances, many borrowers may not be in a position to pay that up front, but they could also certainly be structured so they're paid later on when the loan itself is paid in full. So that's kind of an overview of the pre-workout agreement.
Great, thanks, Chris. And so now we come to the point where you're sitting across the table from the borrower and engaging in a discussion about what's going to happen now that there have been events of default, and the borrower is asking for some accommodations. Often it could be anything. It could be a moving on to interest only for a period of time, getting a deferral on payment obligations for a period of time. And the bank has made a determination, at least an initial determination, that it wants to explore with the borrower a plan for returning to profitability, getting the loan back into performance. And so we need a period of time to put things in place, and during which time the bank is going to forbear from exercising its remedies. Remember, that's kind of the starting point of this, is that there has been an event of default. The borrower has acknowledged there is an event of default. The bank has a panoply of remedies that are available to it under its loan documents, and the bank is prepared to agree to forbear from exercising those remedies for some period of time while something happens. And so the first question is, okay, what's that period of time going to be? And what's the something happens going to be? And again, there are a number of different things that can happen during this period. Perhaps, and now I'm going to make a pitch for at least considering requiring your borrower to engage a turnaround professional. Particularly if we're talking about closely held businesses that have not been in trouble before. Chris has talked about the importance of getting good financial information and reasonable projections. Some of your borrowers are not going to be able to do that, and they're going to need assistance in doing that, and they're going to need assistance in prioritizing where the cash is going to go. And some thought needs to be given to whether a financial consultant, a turnaround professional, can help in that. Much of the time, you're going to meet with resistance. Your borrower is going to say, I can't afford a financial professional. And sometimes the answer is, you can't afford not to hire a financial professional. So that's one of the things that may happen during this forbearance period. And by the way, I think of forbearance agreements and workout agreements as two different kinds of documents. There's a lot of overlap between the two. There's a lot that you would do in a workout agreement that you also do in a forbearance agreement. But in my mind, a forbearance agreement is an interim step, either on the way to full reinstatement of a loan on the original terms and conditions, or on the way to a full-blown restructuring agreement in which any number of changes can be made to the structure of the loan. So for the moment, we're talking about forbearance agreements. And during the forbearance period, the bank and the borrower can come up with any number of things that need to happen in order for the bank to continue to forbear. Perhaps there are excess assets that need to be liquidated. One could provide for the liquidation of assets in accordance with a schedule, deadlines for things to happen. It may be that you get into this forbearance agreement and you've already made the decision that you need to exit this credit one way or another. And you may simply be giving your borrower a period of time to refinance with another lender. There may be other methods that you can provide for in the agreement for loans to be paid off or reduced, requirements for bringing in additional equity, subordinated debt, all kinds of other opportunities that need to be explored to reduce your exposure. And if the plan is for this borrower to restructure its balance sheet, if that's required, or to make restructurings of its business methods or other kinds of changes, then those are provided for in the forbearance agreement also with, again, you want to have measurable performance obligations with temporal limitations so that you know at any given point in time whether there are additional events of default that are occurring or non-performance, because what you are agreeing in your forbearance agreement, generally speaking, is agreeing to forbear from exercising remedies for existing defaults, which are not waived in a forbearance agreement typically. They're just reserved. And you may be agreeing to forbear from exercising remedies with respect to anticipated defaults, whether it's next month's payment or the failure to meet a financial covenant, something like that is anticipated. So, you might say, well, I don't need an agreement to forbear. I can just forbear. And of course that is correct. You don't need to have entered into an agreement to forbear. But you do want to have a written agreement because it, as I said, it sets forth what the obligations are of the borrower during the forbearance period. But it also sets forth what, if any, additional obligations are of the bank, and it provides a clear statement of what the bank is going to do and what the bank is not going to do, because you want to have it clear afterwards that you performed according to your obligations. Of course, in any forbearance agreement, you're going to have releases from the borrower and the guarantors against the bank and its agents for all matters relating to the loan, the documents, and actions up to the time of execution. A forbearance agreement, an agreement to forbear from exercising remedies, is an accommodation to the borrower, and one does not make accommodations to the borrower if the borrower is holding claims over the bank's head. And it's the quid pro quo for entering into a forbearance agreement is the release of claims. Now, we'll talk about this a little more too, is that you may be able to include in your forbearance agreement waivers of certain rights in the event of bankruptcy, such as not to oppose a motion for relief from the automatic stay, or even to provide adequate protection. But all of this gets done in the context of the forbearance agreement. Now, Chris and Rick last week spent a lot of time talking about battening down the loan documents, doing your collateral reviews now, identifying what shortfalls there are in your documentation and your collateral position. This is the document, or the first opportunity to fix some of those mistakes. If there are financing statements that haven't been filed, well, those can be done. The bank can do those on their own. But if there are filings that have been made, mortgages that have been filed in the wrong county, or the property description is incorrect, or there are important trademarks and there's not a separate trademark agreement, security agreement filed with the PTO, or other sort of esoteric rights that haven't been properly perfected, this is where they get perfected now, pursuant to this document. In addition, you may identify additional collateral that you can take during as a part of this of this forbearance agreement. And again, other kinds of ways to shore up your position. So getting into the actual forbearance agreement itself, sort of nuts and bolts. What do you include? How do you say it? What needs to be there? And what is and what isn't enforceable? Every lawyer, it's not like there's a statutory form of forbearance agreement. I can't go to the main revised statutes and find the short form forbearance agreement that the legislature has prescribed. And I can't even go to the ABA's website and find the form of agreement, unlike a standard form of security agreement. But I know that there are a number of things that I want to do. The first thing I want to do, and this is either in the recitals, some lawyers will include these in schedules, is I want to have as comprehensive a list as I can of the loans, the operative documents, the collateral, the parties. I want to have definitions so that everybody knows exactly what I'm talking about all the time. I want to describe the existing defaults, and I want to begin to establish the consideration for the concessions given by the borrower. The first section in my standard forbearance agreement starts then with an affirmation of the loan documents. The obligors, the borrowers, and the guarantors essentially affirm the legality and the binding effect of the loan documents, and they acknowledge full and timely performance by the lender of its obligations under the loan documents. The borrowers and the obligors then go on to affirm the title to the assets that they purport to own and the validity and perfection of the lender's liens. Clearly, we want our obligors to acknowledge the occurrence of defaults and agree to the outstanding amounts of the obligations. You're going to have to prove those at some point in time, perhaps either in a bankruptcy case or in a foreclosure action or some kind of collection. It's always helpful to have your borrower have acknowledged and agreed to the amount of the indebtedness as of a particular moment in time. And if there's principal, interest, default interest, penalties, late charges, fees, you want that reflected there. And you want the borrower, as Chris said, to acknowledge the liability for the bank's attorney's fees and costs on a going forward basis. Now, if we're at the point where we're talking about a workout agreement, you would include a section on the actual structural changes of your loan relationship. And, as many different provisions as you can include in an original loan transaction, you can include in your restructuring agreement. And, the obvious ones are interest rate changes, extensions, or acceleration of maturity dates, grants of additional collateral, addition of guarantors. You might establish lock boxes for payments from account debtors, deferral of certain payment obligations, new reporting obligations. This is an important one. You, together with the borrower and the financial consultants, if there is one, are going to determine what it is you really need to see and how often in order to track how things are going. And these new reporting obligations may be in a forbearance agreement, they may be in a workout agreement, either one or both. Typically in a forbearance agreement, we might see rather not necessarily acceleration of the amounts due under a line of credit, but the closing of the line of credit. Make sure that the indebtedness doesn't grow during this period of time. This would be a place to do that as well. Then we have a section on what the obligors are going to do during the forbearance period. And again, they should be described clearly, and they should be measurable. There should be temporal limitations. If there are document deficiencies that need to give you the new mortgage, deliver whatever stock certificate or other kinds of collateral haven't been in order to perfect that forbearance agreement. If there are other obligations that you've decided need to be in there, this is of assets, hiring of restructuring professionals, production of turnaround plans, reductions in indebtedness, infusions of X fees. We haven't really talked about that in much detail, but it is not uncommon at all to impose forbearance and restructuring fees. Sometimes they get paid over a period of time. Sometimes they get just added to the obligation that needs to be paid at maturity. Sometimes they get paid upfront as a condition to the forbearance or workout transaction. Then we get into what is it that the lender is going to do under the agreement. And here, this is where your agreement to forbear appears. And again, it typically is an agreement to forbear from exercising remedies for a period of time, not necessarily a waiver of existing defaults. There may come a time where the waiver of existing defaults is appropriate, and that would be in connection with the final restructuring agreement. But during the forbearance period, you're not waiving your defaults, you're simply forbearing from exercising remedies. And again, perhaps the forbearance lasts as long as the obligations perform under the loan documents in the forbearance agreement, perhaps until a date certain, with the requirement that the obligations are either paid in full at the end of the forbearance period, or that the defaults have been cured, at least the payment defaults have been cured, and the lender's agreement to forbear clearly terminates upon either the occurrence of a default under the forbearance agreement, the failure to do something that's required to be done under the forbearance agreement, or if the forbearance period simply ends because with the obligations being due at the end of the forbearance period and the borrower unable to make that final payment.
Jack, can I add one thing?
Sure, of course.
Yeah, I just wanted to talk about one aspect of the temporal obligations when it comes to the borrower's obligations, and that is, and this may be an obvious point, but I'll say it anyway. It's with respect to, let's say, the obligation of the borrower is to sell the property, and they're given a 6-month period to do so. And so at the end of the 6 month, you expect the property to be sold and the net proceeds to be paid to the bank to satisfy the obligations. There should be, a tiered approach to that, so that you don't have to wait the entire 6-month period to see if the borrower is really doing what they're supposed to be doing. So I would recommend, and what we have done in the past, is have limitations for each stage of that process. For example, hiring a broker by week 1, listing the property in MLS or wherever by week 2, have a form of, submit all of your offers to the bank and the lender as they come in, accept an offer by this date, et cetera, et cetera. So you're not just sitting on your hands waiting the whole 6-month process, but if they're not delivering and doing what they're supposed to be doing throughout every stage of that process, you have the ability to pull the agreement and pursue your remedies.
Right. It's a very good point. So the next thing I wanted to mention was something that we often do in forbearance agreements, and that is obtain deeds in lieu and or consents to judgments of foreclosure um, when we're talking about real estate collateral. And not at all uncommon, at least up here, I'm interested, Chris and I haven't talked about this, to require the delivery of foreclosure in connection with forbearance and restructuring agreements. And essentially what that is that the borrower executes and delivers the deed to the property, perhaps a release bill of sale for personal property to the lender, so that if there is an event of default and the forbearance period ends, the lender can take title to the property. Now, of course, a deed in lieu of foreclosure is only really an effective remedy if the title is otherwise clear of all liens, claims, and encumbrances, whether they're senior to the lender or junior to the lender. Because if you take it and record a deed in lieu, you take it subject to the liens of record. And of course, that can change during the period of time for the forbearance. So it's a document that you would have, and you may, at the end of the day, determine that it doesn't have all the value that you thought it did, if in the interim there have been liens put of record. But at least it's something that it's an arrow you would have in your quiver at the time. Now, I have found through actual experience that it is best to avoid describing the delivery of the documents as having been made in escrow. Escrow has certain legal connotations to it. The person holding a document in escrow is an escrow agent and has certain duties that we don't want the lender to be subject to in the context of exercising its remedies. So it's better to simply have the documents delivered to the lender, to hold, and to be released only upon the happening of certain events, so that it's merely a contractual arrangement and not some kind of fiduciary obligation with attendant duties. Again, you hold those deeds in lieu of foreclosure or consents to judgment until a default has occurred, and your forbearance agreement makes it very clear that upon the happening of an event of default, you have the right to take it out of the drawer and record it, which then, of course, brings us to other remedies as well. And what is the effect of new defaults under the forbearance agreement? And when does the bank have the right to exercise its remedies? That needs to be spelled out pretty clearly in the document. Is further notice required? Is there a right to cure? And we want to make sure that a default under the forbearance agreement constitutes a default under all the existing loan documents. Then we come to some special provisions that sometimes you will see in loan agreements regarding forbearance and restructuring agreements concerning trying to get the borrower to waive certain rights and make a bankruptcy case less attractive for your borrowers. And first off, you cannot get your borrower to agree that he, she, or it will not file for bankruptcy. Those kinds of agreements are simply unenforceable as a matter of law. The right to file bankruptcy actually appears in the Constitution and came over from England, and it is preserved. Now, sometimes what we will see are agreements in forbearance agreements by obligors to consent to relief from the automatic stay in the event of a bankruptcy. Those agreements, we talked about this, several of us who practice in this area talked about these agreements leading up to these presentations, and they are suspect. They have been approved in certain instances in some of the courts. There's no operative First Circuit law that would govern in our jurisdictions that finds them enforceable or unenforceable in most circumstances. It's going to be a case-by-case determination. It's going to be determined in large part on whether the bankruptcy court and the creditors in the case and the U.S. trustee, all of whom get the chance to weigh in on this, whether the bankruptcy case is an unreasonable second or third bite at the apple, and that the forbearance or restructuring agreement was really the bank's effort to give the borrower what it would otherwise get in bankruptcy, which is an opportunity to restructure its affairs for the benefit of all creditors. And there are instances where bankruptcy courts have upheld agreements to consent to relief from the automatic stay. They may be binding on the debtor. They are certainly not binding on the U.S. trustee's office. They are not binding on a creditors committee. They are not binding on other secured creditors in the case. So they may have some utility in your forbearance or workout agreement, but do not expect to be able to rely on them in all instances. Similarly, an agreement concerning what would be considered adequate protection in the context of a motion for relief from the automatic stay or for adequate protection in a Chapter 11 case. It is helpful, certainly, to have something that the borrower has agreed to. It is not binding on the court, and it is not binding on any of those other parties who have the right to step forward and say, sorry, bank, you are adequately protected by your equity in the property. You do not get payments during this Chapter 11 case. And all that this debtor needs to do is maintain insurance on the property and make sure that your interest in the property is not declining. The value of your interest in the property is not declining. And then a lot of these other provisions are things that Chris already talked about in connection with the both the the reservation of rights letter, the pre-workout negotiation letter, the releases of lender we've talked about, very important, indemnification of lender for the actions taking place, both pre and post forbearance agreement, reservation of rights rather than a waiver, or if there is a waiver, very specific about what is being waived, an affirmation that it's a lender-borrower relationship, that there's a disclaimer of duties of the bank to the borrower, appropriate representations and warranties, waivers of subrogation and contribution by co-debtors, guarantors, the like. A jury trial waiver, you've probably got that in your loan documents already. Always good to say it again. Very important that you have the no oral modification provisions, very clear as to who's got to sign a document, or that no agreement is enforceable until it's signed. And then various boilerplate provisions that we would include, time of the essence, survival, integration, Chris mentioned, interpretation, which law governs, the kinds of things that you would see typically in a loan agreement as well. So where are we on time? Oh, yay. Okay. I think that brings us to the end of the slides, right? So let's see what we have for questions. Oh, we've had free answer during the course. Okay, good. All right, I think they've been answered. Anybody else? Anything that? I do want to make a bald, blatant pitch here. Chris has been at this since the 90s. I've been at this since the 80s. Novak, who you heard from last week, has been at it even a couple of years longer than I have. Between our offices in Portland, Portsmouth, Boston, and Providence, we have somewhere between a dozen and 20 lawyers who have been through these periods quite a bit in the past. Whether we're talking about Dennis Keeler in the real estate group in Portland, or Dennis Robinson in the real estate group in Portsmouth, Steve Del Sesto down in Providence, Chris, Alex, Rick in Boston. We have all been through this before, representing banks in a number of these transactions, and are ready, willing, and able to help you through what promise to be some very difficult times. So again, you know, we think we can match up with any firm in the Northeast when it comes to working through these obligations. And we focus on creditor side representation. Some of us have done a fair amount of debtor work during our careers, but that is not our practice at Pierce Atwood. We are a creditor side practice. We represent banks in putting together and taking apart financial transactions. And you're not going to find better lawyers or more capable lawyers to help you through these very difficult times. So that's my pitch. And thank you all for participating. Hopefully we'll have the opportunity to work together. Chris, any final words?
Just that if there's any other questions that come up later, feel free to reach out to us. Our contact information is on the last slide and also certainly on our website. So please don't hesitate to reach out with any questions you may have.
Thanks very much.
Thanks, everyone.